The Supreme Court is finally about to hear the bump stock case Cargill versus Garland. It's been almost 5 years since the original ban on bump stocks went into effect. So let's review what happened, how GOA responded, and why it matters to the future of gun rights. Hi, I'm Ben, and you're watching the Minuteman Moment. In 2019, the Trump Justice Department and ATF banned bump stocks by regulating them as machine guns. And just so we're catching everyone up, a bump stock is not a machine gun. It's a fun range toy that makes it easier to bump fire, which uses the recoil of a semi-automatic rifle to bump the trigger, increasing the fire rate slightly. But a bump stock isn't needed to bump fire. It can be done with something as simple as a belt loop. Also, an increased rate of fire doesn't make a gun a machine gun. Imagine if shooting fast was a crime. Jerry Michalek would be in solitary confinement for his speed. Well, as you might know if you've watched this channel, GOA sued over ATF's rule. Our case, GOA versus Garland, was litigated in the 6th Circuit. We argued ATF had exceeded their authority in banning these bump stocks. ATF had determined in 2010 that bump stocks were legal firearm accessories. This should sound familiar to anyone that owns a pistol brace, as ATF has continued to use this strategy of regulation to target gun owners. At the first stage of our case in the 6th Circuit, we got an anti-gun judge in a local Michigan court. He ruled against us. We then appealed to a 3-judge panel on the 6th Circuit Court of Appeals, where we won a 2-to-1 decision saying that bump stocks were not in fact machine guns. ATF then appealed this case to an en banc panel, which was a request for the entire circuit court to hear the case. After some recusals, we were left with a split 8-8 vote from the 6th Circuit. Now the law states if there's a split ruling, the earlier ruling from the 3-judge panel, aka our victory, would be vacated and the lower court's decision, where GOA lost, would stand. In an attempt to avoid this outcome, we appealed to the Supreme Court. Well, on October 3rd, 2022, the Supreme Court denied to hear our case. But all wasn't lost. A very similar case, Cargill versus Garland, was being litigated in the 5th Circuit. This case is very similar to ours in that Cargill also argues the ATF exceeded their authority in banning bump stocks. Well, this time, the math worked out and the 5th Circuit Court of Appeals ruled that the bump stocks weren't machine guns. Now this created what's known as a circuit split, when 2 different circuit courts issued different rulings on the same issue. In this situation, our lawsuit in the 6th Circuit and Cargill's case in the 5th. Circuit splits make it more compelling for the Supreme Court to step in and hear the case to clarify the law. GOA recently filed a brief in support of Cargill. Our brief has forced the Solicitor General, the lawyer representing the DOJ to the Supreme Court, to specifically address our arguments too. We're proud to support Michael Cargill in the Second Amendment fight, and we're looking forward to the outcome of this case, when the Supreme Court finally tells the world what GOA and gunners have known for decades, that bump stocks are not in fact machine guns, and banning them was an infringement on our Second Amendment rights. Now thanks for watching. Be sure to check out the rest of GOA's social media to stay up to date with the latest fights for your rights.